Applying that provision here, Mr. Philip took the photographs while employed by the Lagos State Ministry of Culture and Tourism. Since there is no evidence of any contrary agreement transferring ownership to him personally, copyright ownership most likely belongs to the ministry. The Copyright Act also recognizes commissioned works under Section 28, subsection 3. Where a work is privately commissioned for domestic or personal purposes, the commissioner may acquire a non-exclusive license for non-commercial use and may restrain public exploitation of the work. However, that provision does not apply in this case because these photographs were not privately commissioned by Miss Kate for personal or domestic purposes. They were official photographs taken during a public cultural event organized by the ministry. Now, this is where many people become genuinely surprised. Miss Kate, the woman appearing in the photographs, does not automatically own copyright in those images merely because her face appears in them. This principle was reinforced in Donoghue and Allied Newspapers Ltd, where the court held that copyright protects the expression of an idea, not merely the idea itself. So even if a person contributes information or appears in a creative work, that alone does not automatically make them the copyright owner. Under copyright law, the owner possesses exclusive rights over reproduction, publication, distribution, and communication of the work to the public. Therefore, where a person commercially exploits a protected work without the owner's consent, copyright infringement may arise. Applying this principle here, Mr. Philip allegedly used the photographs after resigning from the ministry to promote his modeling agency business. If done without authorization from the ministry, such commercial use may constitute copyright infringement. So are there remedies? Under Section 37, subsection 2 of the Copyright Act of 2022, where infringement is established, several remedies become available. The plaintiff shall be entitled to damages, injunctions restraining further use of the work, account of profits, and delivery up. Now, regarding joinder, the law permits a party with sufficient legal interest in a matter to be joined in an action. Since the ministry likely owns the copyright in the photographs, it possesses a direct proprietary interest in the dispute and may validly apply to join the suit either as a co-plaintiff or an interested party. Then comes the most modern and controversial aspect of the case. Mr. Philip argues that AI tools were used to generate the photographs, and therefore the Nigerian Copyright Act should not apply. This raises a major unresolved question in intellectual property law. Can AI-generated works receive copyright protection where there may be insufficient human creative authorship involved? Because under Section 2 of the Copyright Act, originality depends substantially upon human effort. In conclusion, the Lagos State Ministry of Culture and Tourism